investigations that the NBI submitted, which the DOJ asked them to correct and to provide additional information, which they complied with. And what is now at issue is the February 10 affidavit investigation. That's why I'm now objecting on the grounds of relevance. Your Honor, let me finish. What's the point of digging into a prior affidavit investigation when what this witness testified to, when what this witness identified is a later affidavit investigation that is now being considered by the DO? The question is simple: what's the relevance?
Objection is overruled. It goes into the credibility of the witness as well as his ability to testify as to his investigative report. And witness is competent enough anyway. Witness may answer.
Yes, Your Honor.
No, Your Honor, we received that letter on 10 February 2025 based on the second letter submitted to Honorable Richard Anthony D. Fadulyon, signed by Judge Jaime B. Santiago. It states here that on 10 February 2025, this Bureau received the certification dated 05 February 2025, where the evaluating prosecutors referred the case for case build-up, citing reasons thereof.
Then in that case, Your Honor, we have a problem because this is
Your Honor, objection.
I'm not yet.
Objection.
Kindly let counsel finish.
Because like, as I mentioned a while ago, Your Honor, this forms part of the records of this honorable court. This was submitted as page 10 to 11 of Annex G9. This is part of the court's record, and we also received this. These are not our documents.
That's why I'm objecting, Your Honor.
The prosecution's, the
Counsel for the prosecution, kindly let him finish.
These are not our documents, Your Honor. These are part of the records of the court. This came from them, and they attached this to the articles of impeachment. Your Honor, we have all the right to confront each and every document because that forms part of the charge against our client. Now, if Attorney Lontoc is saying, Your Honor, if I may just be allowed to finish,
manifestation
that it was received on February 10. We just want to counter-manifest, Your Honor, that there is a received stamp here, says February 5.
Your Honor, this is not highly...
Counsel, the presiding officer already overruled the objection of counsel for the prosecutors, and I thought you would end up with a question. Kindly proceed with your cross-examination.
So in other words, you deny that it was received on February 5, 2025, as seen here in this document that is part of the records of the Senate Impeachment Court.
Well, first, Your Honor, hindi ho ako yung nag-receive niyan. Then pangalawa, ang nakapirma ho rito ang dating director namin, Jaime B. Santiago, at ang sinasabi niya, on 10 February 2025, this Bureau received the certification dated 05 February 2025.
Alright, anyway, I'll move on to a new point. This certification noted 7 items, and we went through this the last time with Agent Calilo, so I won't delve on that. But basically, just to go through this very quickly, the first point says that there is no affidavit of the person, so no affidavit. The second point is, or the second note is, the press briefing conducted on October 18, so no TSN and affidavit of the person taking the TSN. Number 3 is annexes I and K with marking, so no affidavit of recorder and no TSN and affidavit. Number 4, Annex L did not indicate who made such TSN, so incomplete information. Number 5, the affidavit of Juan Patria Morales, so no USB. Number 6, only the minutes of the meeting with several persons, so no affidavit. But I'd like...
Oh, Your Honor, that's my objection now.
I'm just reading
What
it,
is
Your
the
Honor.
question?
Wait for the question.
Kindly
I'm going to the question. I'm just laying the basis, Your Honor. Now, I'd like to highlight note number 7. Please allow me to read that portion, or at least the latter portion thereof. It says there, in the instant complaint, only the NBI executed an affidavit and there was no participation on the part of the offended parties. As it appears, NBI is not the offended party for the crime of grave threats. My question is this. So based on note number 7, according to the DOJ, the NBI is not the offended party, correct?
Based on number 7, NBI is not the offended party for the crime of grave threats.
Okay, very well. So the offended parties, if at all, are President BBM, the First Lady, and the former Speaker, correct?
Yes, sir.
At any rate, all these, the 7 notes that I mentioned, are all deficiencies in the first affidavit of investigation, correct?
It's not deficiency, Your Honor, because the first affidavit that we've submitted is substantial in terms of
Substantial.
establishing the evidence required. This requirement is a matter of complying the required quantum of evidence required under DC-20. And if I may, sir, the purpose of submitting our referral to the Department of Justice is for preliminary investigation, which under the NPS rules, the new rules under the NPS, the law enforcement agency can submit a complaint affidavit, or in fact submit a complaint before the DOJ for purposes of preliminary investigation. The requirement that the offended party should have the complaint affidavit is not an indispensable requirement, and so far as the preliminary investigation is concerned. And so far as the preliminary investigation is concerned.
Very well. Now, based on that answer, I'd just like to point your attention to the portion of this certification dated February 5, 2025, next to the box ticked with an X. Kindly allow me to read, if we can highlight that portion. Okay, it says here, and you can read with me, insufficient for the conduct of preliminary investigation and must first be referred for case build-up. So in Filipino, this is my question, I'll do it in Filipino. So in other words, nakulangan yung DOJ, correct?
For purposes, Your Honor, of satisfying the elements, the required quantum of evidence, the DOJ required us to attach the affidavits and other documents like the TSN, sir.
Thank you. And the DOJ itself mentioned this, correct? Or said this, correct?
Based on the certification.
Alright. In fact, let me direct your attention to the portion after, I quote, must first be referred for case build-up. Can we flash that also on the screen? And allow me to read. The complaint/referral does not contain all the necessary evidence to prove the essential elements of the crime. Therefore, it is recommended that the same be first referred for case build-up. Okay? Now, let me get this straight. I'll summarize first and then I'll ask the question. So the subject incident happened on November 23, 2024, and the NBI conducted fact-finding investigation, as you said. You subpoenaed individuals, conducted interviews, gathered evidence, among others, as you said also, and the NBI spent over 2 months or until January 30, 2025 for this process. Is this a fair summation of what we had just discussed?
I don't think so, Your Honor.
You don't agree. And yet, when the NBI transmitted the case to the DOJ on January 30, 2025, the DOJ found it to be insufficient for the conduct of preliminary investigation.
Objection, Your Honor. Continuing objection as to this series of questions as to the prior affidavit investigation, which was corrected in a February 10,